In today's video, we're going to be looking at the living documents and breaking them down into a theoretical understanding of what they are and how they can be used for us in estate planning. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, these videos are for educational purposes only. I am not giving legal advice. And second of all, we're going to be talking about Minnesota law here. So if you have questions or in another jurisdiction, make sure to talk with an estate planning professional licensed in your jurisdiction before you plan your estate. So what do I mean by the living documents? Well, in previous videos, we've talked about there are 5 core estate planning documents that everyone should be aware of before they plan their estate. The revocable living trust, the will, the durable power of attorney, the Health Care Directive, and the Guardianship Directive. When I say living documents, we're talking about only those that are effective while you're alive but incapacitated, and after you pass are ineffective. After you die, those are the testamentary documents. The living documents are the Health Care Directive, the Durable Power of Attorney, and the Guardianship Directive. These are each a form of power of attorney. Now, a power of attorney is a document that very simply authorizes someone to step in your shoes and make certain decisions on your behalf. The person who steps in your shoes is your fiduciary. Being a fiduciary means they have to make decisions in your best interests on your behalf, even if they conflict with their own self-interest. Now, for each of these powers of attorney, we are not just giving carte blanche right to step in your shoes and make all sorts of decisions. We limit those by the type of decisions and when and how they can make those decisions through 5 different characteristics of powers of attorney. The first category is purpose. There are 3 purposes that we care about in estate planning. And by purpose, I mean the type of decision someone can make. There's medical decisions, which would be given under a healthcare directive. There's financial decisions, which are given under a financial power of attorney. And there's guardianship of minor children, which is provided underneath a guardianship directive, or technically they're called a designation of temporary standby custodian. I call them guardianship directive for ease. Now, there are other types of decisions that a power of attorney can authorize. For example, there are tax powers of attorney, a specific form that you provide to the IRS that authorizes your enrolled agent or CPA to represent you in front of the IRS. But that's not an estate planning document, so we're not going to worry about that right now. The second category is durability. Power of attorney is durable. That means it's effective while you are incapacitated. If it's non-durable, that means it's effective only until you become incapacitated. And once you become incapacitated, it becomes ineffective. For estate planning, we are certainly focused on the durable power of attorney because that's what we're planning for, is incapacity. When I say incapacity, I mean you are legally unable to make certain decisions on your own, usually because of dementia, Alzheimer's, multiple stroke, or coma, or something of the sort. Third characteristic is the term. A termed power of attorney is effective until a specific event or date. A non-termed power of attorney is effective until your death or rescission. Now, in estate planning, generally, we are focused on the non-termed power of attorney. The fourth characteristic is going to be scope. Now, this is for financial powers of attorney only. Under the Minnesota Financial Durable Power of Attorney statute, there are 13 enumerated authorities that can be given to an attorney in fact. If it's a general power of attorney, that means you're giving all of those authorities to your attorney in fact. If it's a limited power of attorney, you're just giving some of those powers or even just one of those authorities to your attorney in fact. The final characteristic is the trigger, and this is a big one. An immediate power of attorney is effective immediately as soon as you sign and notarize that document, as soon as you properly execute the power of attorney. If it is springing, that means the effectiveness only occurs upon the occurrence of an event. So when I say immediate, we're looking at, for example, the statutory durable power of attorney in Minnesota. As soon as it's signed and notarized, your attorney, in fact, has all the authority granted under that power of attorney, whether you're incapacitated or not. If it's springing, For example, upon your incapacity, then a healthcare agent, for example, will only be able to make healthcare decisions when you become incapacitated. Now, incapacity is not the only trigger. For estate planning, sometimes think of the Guardianship Directive, we will use unavailability or such as kidnapping, or you go to prison for a certain amount of time. The uh, Guardianship Directive can kick in. Some durable powers of attorney are springing. Uh, some all healthcare directives are generally springing, though sometimes with a mental health care directive, it's not only on incapacity, and guardianship directives for estate planning are always springing. There is one final characteristic that everyone should be aware of about powers of attorney. They are incredibly powerful and give a lot of authority to the attorney in fact. When we're looking at a durable financial power of attorney, we can be authorizing someone to have access to all of our worldly goods. For a healthcare directive, we're authorizing someone to make life and death decisions on our behalf. And for guardianship directive, we're authorizing someone to make life or death decisions for our children. Now, the possibility of misuse is there, but if you do misuse a power of attorney, or your attorney in fact misuses a power of attorney, there are stiff penalties. For example, a durable financial power of attorney, if misused and caused damages to the principal, the attorney in fact can be subject to treble damages, 3 times the amount of damages that they cause in penalty. Healthcare directive and guardianship directive, if they're misused, it can be criminal liability, meaning you go to jail. So we don't want to misuse powers of attorneys. There's a few other things that I want to point out about powers of attorney. First of all, based on all of that, make sure to pick your fiduciaries carefully. In fact, your attorney should be sitting down and working with you to make sure that you pick the right fiduciaries. Sometimes your brother and sister might not be the right person to be the attorney in fact under a durable financial power of attorney. Sometimes mom and dad might not be the best guardian of your minor children, and sometimes your spouse might not be the obvious choice for a healthcare directive. Second thing you should be aware of is that instructions are not always inherent in a power of attorney. With the healthcare directive, we have the living will. And in the living will, we give instructions on what decisions we want our healthcare agent, which is the healthcare attorney in fact, what instructions or decisions we want them to make on our behalf if we are incapacitated. We don't have anything like that for the durable financial power of attorney or guardianship directive. That doesn't mean you can't write it. You can write out instructions for your attorney in fact under a durable financial power of attorney. You use these, here are my assets, they're held in these accounts, do not touch these assets, etc., etc., etc. For guardianship, you should absolutely be giving instructions about your children. Who is their doctor? Where do they go to school? Who are their best friends? What are they allergic to, etc., etc., etc. Remember, kids are not always that bright. If you ask my 2-year-old where she goes to doctor, she has absolutely no idea. Third is these are incredibly valuable documents. Let me give you an example. An early client of mine came to me and they just wanted a will. They didn't want to deal with the healthcare directive or durable power of attorney. They wanted to save a buck. And that was fine. So we drafted their will after I advised them about what could happen, and they went on their merry way. Several years later, in fact, last year, they came back to me and said, hey, the wife came back to me and said, my husband had a very fast cognitive decline with early onset dementia of some sort. And he was in memory care, and he currently lacked capacity to make decisions for himself. Unfortunately, that also meant he lacked capacity to sign a durable financial power of attorney, and she needed one to pay medical bills. That meant that instead of spending a little bit of money years ago to get the durable financial power of attorney in place, they had to now spend thousands of dollars to do a conservatorship hearing, take several weeks, if not months, to get a conservator in place to be able to do just about the exact same thing that the attorney in fact would have been able to do under a durable financial power of attorney. They lost thousands of dollars and a lot of time that they didn't want to have to deal with. So they're very valuable. Get them in place as part of your estate plan. Don't skip out on the living documents. So this has been my take on the living documents and a theoretical breakdown of what they are and how do we truly understand them. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. We do new videos every other Wednesday. Right now, peppering in videos on the Essential series throughout, so those will be coming up as we go. If you have any questions, leave them in the comments below or just send me an email. I'm happy to get back to you, or if you want to do a free consultation, my email and phone number will pop up at the end of the video. Otherwise, until next time, this is Gregory Singleton with Signature Law.